Substantive due process. Substantive due process refers to a requirement that laws and regulations be related to a legitimate government interest, such as crime prevention, and they not contain provisions that result in the unfair or arbitrary treatment of an individual. The first section here is that the government must have some sort of interest, and not only some interest, but some sort of legitimate interest. They have to in some way say that this is something that the government should be involved in. And then secondly, the law itself cannot have provisions that result in unfair or arbitrary treatment of an individual. So you can't discriminate. You can make things unfair for a certain party that wouldn't be fair for another, or you can't treat people in an arbitrary manner. The courts impose limits on governmental powers and authority. So judges, instead of legislators, may define and guarantee the fundamental fairness, justice, and liberty. That means that the judges get a chance to take a look at the laws and determine whether or not there is a legitimate government interest, and if the law is being applied in an unfair or arbitrary manner. Due process is an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Suppose, for example, a state law gives students the right to a public education, but it doesn't say anything about discipline. It just says you can have it. So before the state can take away this right from a student, take away the public right to an education, say by expelling this person for misbehavior, it has to provide fair procedures. In other words, it has to give due process. So if you have the right and it is given to you by the state or by the national government, then it can't just be taken away without this due process. Substantive due process is the most common way to recognize what are called unenumerated rights. These are rights which are not actually written down in the Constitution. Unenumerated just means they're unnumbered. So they're not written down anywhere for us to look at and say, well, this is actually a right that has been laid out by a legislator or laid out in the Constitution. The Supreme Court of the United States decides which rights are fundamental and cannot be deprived by the states. So it's by case law that we're really realizing what these different rights are, and we're getting fundamental rights by different laws being brought up to the courts, and the courts deciding whether or not these laws are infringing upon a right which can't be taken away from people by the state government. And really it's determined by the seriousness of the impact on the individual. The law says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." This is where the fundamental rights part comes from. And ignore that line that says due process right in the middle. I don't know why that's there. But it's supposed to read, "Nor shall any state deprive any person of life, liberty, or property without due process of law." What this is it's saying, courts, here's an opportunity for you to extract fundamental rights from this. The law itself says liberty or property. Now, what the court determines liberty and property to mean is going to be what our fundamental rights are. So let's take a look at a couple of cases which will help illustrate those for us. Liberty or property can be defined in a couple of different ways. A deprivation of liberty occurs if a person loses significant freedom of an action or is denied freedom provided by the Constitution or statute. So something is being taken away from them in terms of their ability to do something. Their denial of constitutional rights also qualifies as a liberty interest. So if your right to do something constitutionally is being taken away from you, then that can be a liberty interest and a deprivation of liberty, which requires due process as well. A deprivation of property occurs if the person has a reasonable expectation that they're going to continue to receive that benefit, and for some reason that entitlement is not fulfilled. In other words, they expect that they're going to continue to receive or continue to have or possess something, but for some reason they're not. For some reason it's taken from them. And so this would be a deprivation of their property interest, which would require due process. Let's talk about property interests first. So the substantive due process piece which deals with property interests, very easily seen in the 1905 case of Lochner versus New York. what was happening here is that there was a law in New York that bakers could only work a 60-hour work week. It was supposed to be something which was helping labor laws because I don't know if you've ever done baking or known bakers. They get up really early in the morning and they tend to have very, very long days. And so there was a law that was put in place by New York that said bakers can only work a 60-hour work week. You cannot make them work longer than that. And so the question came before the court, does this violate the property interest of the baker? Did there have to be something going on here? And the court actually struck down the law. They said that there is a 14th Amendment right here. Remember, we're dealing with the states. And this is violating the baker's rights to enter into contracts. They should be able to, if they want to, contract their life away and sign themselves into some sort of working agreement or contract where they're going to work 80 hours a week if they want to. Because their property here is their labor. Their property is being deprived because they have the right to freely buy and sell their labor. And if they want to sell their labor at 80 hours a week for a shift or whatever it is, then that is a property that they are entitled to, and depriving them of this can't stand. Liberty interests are somewhat different. For example, we're looking at in the 1920s, the court overturned some state laws prohibiting the teaching of foreign languages and private schools. So really the freedom to learn what you wanted to learn, sorry, that should say in private schools, by choice, by choosing these things. And this is just part of a whole group of other fundamental rights which the court has upheld over time. So this is part of the fundamental right to educational choices and a parent's fundamental right to choosing the education for their child. Similarly, the right to a contraceptive device, for example, which the court has upheld to be fundamental rights, along with other rights that you see here in this list, like the right to refuse medical treatment, which we'll talk about in a minute. Now, this doesn't mean that the court always made decisions that made a whole lot of sense. Whether or not there was some sort of interest involved was a decision that they had to make, but sometimes they came out with some very bizarre results. Case in point is Buck versus Bell. This is 1927. During that time, 24 states had laws which allowed imbeciles to be sterilized against their will. Imbeciles is just not a nice name for somebody. It's actually a categorization of individuals who have below a certain IQ. And so if you took an IQ test and you got a very low score, you may have been placed into the category of imbecile. In this case, we had an individual who was labeled as an imbecile because she had an IQ of below a certain amount. And she was institutionalized she was placed in an institution for the feeble-minded, which we had in 1927. And this was the plaintiff Buck's mother. Now, Buck had been raped and had given birth to an illegitimate child. And so the question was really in terms of this person's particular rights, what was going to happen here? Do they have a right to freedom? Do they have a right to their liberty? Or do they have to be institutionalized for being feeble-minded? Or do they have to be sterilized against their will? Do they have the right or the freedom not to be sterilized? In this case, the court said, and this is a direct quote from this particular case, that 3 generations of imbeciles are enough. And so therefore, if you are an imbecile, you do not have the right to be free from involuntary sterilization. And so this right was denied, and so they're saying there is no liberty right in this particular case. Another case which many are familiar with, this case is Roe v. Wade. This is in 1973, and this particular case dealt with whether or not, this part of the case that I wanted to look at, it's a long decision and it held very many things, but this particular section of the case that I want to look at dealt with the fetus's right to life. Not necessarily does the woman have the right to an abortion, but does the fetus have a right to life? Remember, we were talking about not depriving individuals of their life, liberty, or property. Well, it would seem like depriving a fetus of the right to life may be something that we would look at here as requiring this type of substantive due process. And the court looked at this and they said, here's the problem. The law specifically says all persons born or naturalized in the United States. See that word born there? This particular person hasn't been born yet. And so they don't actually have to get the rights because they are not born, and so they do not come under the protection of the Constitution of the United States. And since the fetus is not yet a person, because they're not yet born, they cannot yet exercise their rights, and so therefore it is not deprivation of life or any right that they would have, because they have no rights which can be deprived. This is ironic because the court held that corporations were citizens and had actual rights that they could exercise, but that's another case altogether. And the question then became, well, then at what point does this fetus become a person? At what point are they born, quote unquote? At what point do they actually have the ability to exercise their rights as people? And then this became the question of viability. In other words, when would that fetus be able to live without their mother? And by the way, fetus, for those of you who don't know, it's just a word for an unborn person. So a baby who has not yet been able to live outside of their mother's body would be a fetus. And so that's why this question of when can this fetus live, not necessarily when it's going to come out of its mother, but when could it possibly, if the baby was removed, the fetus was removed from the mother, would it be able to survive on its own without the surrounding environment of the mother's body? And so the court came up with this idea of life being viability. And the states can regulate when the fetus is actually viable. And different states actually were saying different things, and this is why it came to the court. Is some states were saying, well, the fetus is viable at birth. And other states were saying, well, actually the fetus can survive outside of a woman's body before it's actually born. In the third trimester, there is a lot of evidence that fetuses who had to be born early before their natural gestation period ended could actually survive. And so there was this big conversation between the states in terms of when this fetus could live by themselves. And so the Roe versus Wade decision said, in the third trimester, the states can forbid abortions of viable fetuses. It said that's the situation where they might actually be alive enough that they can assert their rights to life and assert their interest in their liberty interest in actually being able to not be aborted, and therefore the states could legislate and forbid abortions in that particular instance. And they made the exception that unless the life or the health of the woman was in jeopardy, that could be an exception to this particular law. We had a follow-up case in 1992, less known case. This is Planned Parenthood versus Casey. In this case, the states were allowed to regulate abortions if they did not place what's called an undue burden of the woman's right to an abortion. Now, this seems to really open the door a lot to more reproductive rights and more opportunities for abortions in this particular context. However, the court clarified itself by defining undue burden. The way that undue burden was defined was a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. Now, if we had left off the words of a non-viable fetus, we would have had a very different liberty law here when it came to the idea of when states could interfere with a woman's right to have an abortion. However, because we have the of a non-viable fetus part attached to the end of that, we're going back to viability, and that's why you don't hear too much about this case, because it really didn't change the law that we saw in Roe versus Wade the way that a lot of advocates had hoped that it would. Lastly, we have Cruzan versus the director. This is the Missouri Department of Health. This is 1990. What happened in this case is that we had Cruzan. Cruzan was in a vegetative state. So in other words, Cruzan was on life support, unable to survive without the help of the devices in the hospital. And the liberty here at question was, does Cruzan have the right to refuse medical treatment? In this case, if Cruzan refused medical treatment, Cruzan would die. Cruzan was not in a situation where without the use of all of this equipment and all of this treatment, that Cruzan would be able to survive. And so the case really was about whether or not Cruzan could be refuse the medical treatment, be unplugged per se, and then go ahead with whatever would happen at that point. So the court took this up, and they upheld that the states could. The court upheld this right first off. So upheld the right to refusal of medical treatment. So you can go in and refuse medical treatment. However, if it's in a case as strong as Cruzan's, where without medical treatment they would not survive, the court said that the states could require strong evidence that the incompetent person wanted to die in such circumstances before it ended medical treatment. This is why, for example, you see a lot of advanced directives which are being written now. And so if the patient, before going, for example, into a medical procedure in which they may or may not recover, they can sign an advanced directive, they can sign something which would be evidence for the state, evidence for the court saying, if I end up in a vegetative state, I would want to die in this circumstance, and so therefore I can refuse medical treatment, and I'm making an active decision to do so. Without that evidence, however, it is more difficult, and it is up to the states and their particular laws to say whether or not the right to refuse medical treatment would be applicable, given that there was no strong evidence in a particular case. In 1997, we had a little bit of a follow-up case where we tried to, or not we, the plaintiff here tried to extend the Cruzan case to the idea of physician-assisted suicide. If I have the right to refuse medical treatment, as I do under Cruzan in 1990, do I have the right to ask a physician to aid me in taking my own life? And the court said, we are actually not going to extend that right. That is not a liberty that you have. You have the right to refuse medical treatment. You do not have the right to actually take your own life through physician-assisted suicide. And so they refused to bring it further in that way. But you can definitely see how both types of substantive due process are morphing and changing over time, and by different cases seeking to stretch the limits of these different liberties and property interests, how we can see how this is going to develop, and how we can see this substantive due process piece of this whole thing really working in conjunction with procedural due process to give us protections against the state and what they can do, and how we can have rights emerge, not only procedurally, but through case law in terms of what fundamental rights we can expect as citizens.